Court. Now sitting at Boston with him and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and to my right, Justice Ditkoff, and to my left, Justice Grant. We will be hearing 5 cases this morning, following our ordinary practice, which is 15 minutes per side without rebuttal. The first case we will hear, maybe if I can figure it out, is number 22-1244, Commonwealth versus DALEY, and we will hear first from Attorney Hartley. Attorney Hartley.
Good morning, and may it please the Court. Brooke Hartley for the Commonwealth. This Court should reverse the allowance of the defendant's motion to suppress, where it is uncontested that the gun was abandoned before the seizure, and in any event, the police had reasonable suspicion to stop and pat frisk the defendant based on the following 5 factors. First, the temporal and physical proximity to the shots fired. Second, his statement to his other male companion to be cool. Third, that he was walking at a fast pace with his hands in front of his body. Fourth, his popping up from behind the Subaru. And fifth, his unprovoked flight in the opposite direction after that, the opposite direction he had been previously traveling. So beginning with the temporal and physical proximity, the defendant was seen by the officer about a minute after the shots were fired. He heard the radio call at about 8:29 and turned directly onto Blue Hill Avenue, where the defendant and his 3 companions were seen. This is obviously the same street where the shooting happened. And I would submit to your honors that this is very distinguishable from the physical proximity, the temporal and physical proximity as considered in Warren. In that case, that was completely discounted because the defendant was seen a mile away about 25 minutes later, and his flight path had been mere conjecture.
Can you, I know you're going in order, but the one I'm really interested in is the popping up behind the Subaru.
Yes.
Why is that suspicious of having fired the shots? I mean, it might be odd, it might be evasive, but I'm trying to figure out what it has to do with firing the shots.
So the inference there, Your Honor, is that he was hiding the gun. This behavior takes on a greater significance when considered with the other factors that I listed. So when the officers saw him at first, he was not a suspect. He was simply in the area, and the officer was looking for information. His behavior after that, his arguably consciousness of guilt statement to his friend to be cool, which the officer interpreted to mean don't talk to the police. The
problem we have with lots of this is that we know that avoidance of the police, we're told by the Supreme Judicial Court, is not inherently suspicious. And maybe everyone thinks be cool means different things. I read him to be saying, don't talk to the police, which of course is what he immediately cuts off his conversation with the police. But not wanting to talk to the police, or even not wanting to snitch or whatever, that's not, anyone could have said that to him.
Well, certainly there are many interpretations of what be cool could have meant, but in the reasonable suspicion analysis, the inference need not be necessary or inescapable even. It just has to be reasonable.
What do you think the inference of be cool is?
The inference of be cool, the officer testified, was that he found that statement very odd and believed that it meant to stop talking to the police, which that individual then immediately did. He walked away and the conversation
But he didn't say, I think it meant stop talking to the police because I'm going to get in trouble.
No, he didn't go that far. But again, this is just one factor when considered in the totality of these 5 factors that suggests that to the officer that right immediately after a shooting happened that this individual had a gun, was trying to evade police detection, and that is why when he walked at a fast pace in front of his body, the inference was that he had the gun on him. Again, by itself.
I see no evidence in the record that as a matter of training or experience, the officer thought that the running with the hands in front of him, even in his waist area, but he couldn't see the hands.
So I would agree with Your Honor that the officer doesn't specifically tie that to his training and experience. He does testify early in the hearing that he has been trained on the characteristics of an armed gunman.
But he never says, and these are the characteristics of an armed gunman. He just describes it, right?
I believe he talks about certain bodily positions and a security check that would suggest to officers.
Yes, that's a blading that isn't going on, right? That's the discussion of blading. I mean, it's on cross-examination.
A security check from what he describes, not in relation to this, but would just be grasping the waistband. I think.
No, I mean, we see obviously lots of cases like this, so we hear a lot of the different things, but I had never heard before just having your hands in front of you meant something.
So, and by itself, Your Honor, I don't think it would mean anything. I think it is just.
But you do think that grabbing your waist would?
I think it depends on the other factors that were at play here. There are certainly cases where the court says, well, it's not unusual for someone to get out of the car and to adjust their waistband to pull their pants up. That's not necessarily suspicious behavior that contributes to the reasonable suspicion analysis, but it might be if we have 5 other factors that make this officer think this individual was carrying a legal firearm. So again, and I sound like a broken record, but each of these behaviors takes on a greater significance when considered in the totality, and also when considered in relation to the gravity of the crime. And that is not a factor in and of itself, but it's certainly relevant to the analysis, and it colors this officer's observations. What we're talking about here is reasonableness. When he's investigating a crime of shots fired, that is certainly relevant.
Has any appellate court said that shots fired is the kind of serious crime that, I guess what you're saying, lowers the otherwise, what otherwise would be the bar for reasonable suspicion?
I think so. If you look at Commonwealth v. DePina, the court says... Is
that a shooting?
Your Honor, I believe that the DePina is just possession. I'm not...
And that's considered a serious enough crime that we don't use our ordinary reasonable suspicion?
So the court says that the gravity of the crime in that case and the present danger and these circumstances may be considered in the reasonable suspicion calculus. So I think really anything with a firearm would present a significant public safety.
I've seen this said maybe in dictum by Justice Ginsburg, but she was talking about bombs and terrorism. You know, she wasn't talking about what unfortunately are run-of-the-mill kind of gun crimes.
Well, it may be
none of them is run-of-the-mill, but there are, of course, hundreds of them, unfortunately.
Yes, and Your Honor, it may be more common to have a firearm crime or a shooting or a gun possession than a bomb threat, but the danger to public safety is certainly still great when someone's carrying an illegal firearm.
I agree with that.
What exactly was the defendant moving to suppress?
So there's no question that the defendant was moving to suppress what the defendant refers to as an identification. So really, it was the defendant's statement of who he was. I'm TRAVAUN DALEY. It's not really an identification in the sense that we normally talk about it. There's no ID procedure here that the defendant is moving to suppress. And I think the reason why the Commonwealth is pursuing its appellate rights in this case is because of the judge's ruling. And that ruling encompassed much more than just the suppression of his statement, I'm TRAVAUN DALEY, or an identification. That if you look at page 58 of the Commonwealth's appendix, her ruling is, the motion to suppress the seizure of Mr. DALEY is allowed. All actions which followed the seizure is suppressed as the fruit of the poisonous tree. So suppressing all actions that followed the seizure in this case is really tantamount to a dismissal, even if the stop was improper. That's not the remedy.
I don't understand that. And of course, we'll ask your opposing counsel. You wrote your brief, I think quite reasonably, thinking they're suppressing the gun. Your whole brief is they're trying to suppress this gun. I'm not sure exactly what opposing counsel meant, although we'll ask her. It seems like maybe what she means is, no, we don't care about the gun. It's the identity of the defendant that can't be used. Are you saying you don't object to not using the identity of the defendant?
No, I'm not saying that, but what I am saying is, first of all, that I think the motion judge's order encompasses much more than that, which I think is problematic regardless of what the defendant
Well, but
is
I don't
making.
know, it doesn't list the things that have to be suppressed at all. I mean, that may be a weakness in this. You didn't cross-appeal on, or you're the appellant, you didn't list that among the issues. We have no idea what she means. How would you ordinarily figure that out?
Well, I think we do know what she means. I think this language is although it's odd, it's not imprecise. It's quite clear that she says the actions which followed the seizure are suppressed. And if you look at the hearing.
But really, the rule, I mean, I read that to mean that were the result of the search, right? Obviously, if 2 weeks later you get a telegram from a witness who says it, that can't be suppressed. It's got nothing to do with if it wasn't caused by the search. You thought the gun. They're saying, no, not the gun.
So I think the gun is encompassed in this, and I think what my sister, and she certainly can correct me when it's her turn, but is arguing that without the identification, the Commonwealth can't go forward.
If a day, go ahead.
Counsel, let me try it this way. Let's say we affirm everything but the last sentence of the judge's opinion, everything but that fruit sentence. And your friend gets up and says, well, look, in my view, the officer can get up, can testify all the stuff he saw, but what he can't do is say, and I recognize it's that guy there sitting at the defendant's chair. He can't say that, and he can't say, obviously I arrested him and got his ID. If your friend says that, and we think there wasn't reasonable suspicion, do you think that's the right scope of suppression?
No, Your Honor. I don't. So I think in this case, there was no, so if I can take a step back to the purpose of suppression under the exclusionary rule, which is to deter unlawful searches, as this court well knows. And that rule is calculated to prevent, not to repair. So you can't suppress an act, you can deter an act by suppressing a fruit. So in this case, on the Commonwealth's point of view, there was no fruit to suppress. The defendant's statement, I am TRAVAUN DALEY, was not a fruit, although I suppose it could have been suppressed as technically that. But the name, the statement, I am TRAVAUN DALEY, even so, is not really incriminating evidence. For instance.
Let me try it a different way. If we find there was no real suspicion, what should be suppressed, in your view?
If you find there was no reasonable suppression, what should be suppressed? So I think that's the problem with this case, Your Honor, is that there's no fruit to suppress here. The remedy would not be suppression. I think what defense counsel should have done if there was an issue with the stop is move to dismiss based on lack of probable cause. And that would certainly be a different case if the officer should not have made the stop in the first place. But here, there's really nothing to suppress. So a motion to suppress the gun would, and I think that's why the ruling is crafted the way that it is. So there's nothing to suppress because if you move to suppress the gun, that fails because I think we agree the gun was abandoned before the stop. There's no identification here, so we can't suppress that. Motion to suppress statements would be waived, but even so.
When you say there's no identification, you mean the officer won't identify the defendant at trial?
So I mean there's no identification in the sense that there was no identification procedure that would be suppressed. So if we suppressed the statement that he said he's TRAVAUN DALEY, I don't think that really impacts the Commonwealth's case because the officer can testify to his, and I think my sister would disagree with me here, can testify to his observations of what he saw and still say that that's the person I saw do those things when I was on Blue Hill Avenue.
But how would you know whether he can ID him just from the stuff he saw before the illegal seizure and not from the stuff that happened afterwards?
How would we know?
I mean, it's not impossible, but
Well, yeah, I think based on these facts, it's very likely that he could ID him before it, not to mention that this is there's a surveillance video here. So,
I thought it was incredibly bad quality. I'm not sure if we have it. I haven't looked at it yet, if we do.
yeah, you don't have it. I can get it to the court if you'd
Okay.
like. I wouldn't say incredibly bad quality. I'm not sure that you could make out if the officer hadn't seen him in person beforehand, hadn't stopped and talked to him, it's quite possible that he maybe would not be able to pick him out based on just viewing that video. But he did. He spoke with his friend who was standing right next to him before the stop, and he watched him walk up the street, he watched him pop down, he watched him run the other way. So I think his ability to describe his observations and say, that's the person who I saw do that is quite reasonable in this case.
You didn't raise this below as a defense to the motion. Look, his identity isn't a fruit of the poisonous tree because he saw him before he got out of the car.
No, Your Honor. No, we did not. And I think there was probably some confusion at the motion to suppress hearing about what was being suppressed.
Yeah.
And I see that I'm out of time. Does the court have any further questions?
Unless there are further questions, no, but we have your brief, and that was an excellent argument, so we've heard your argument as well.
Thank you, Your Honor.
And we will hear next from, why do I never just, it should be easy, from, I will mispronounce this probably, but Attorney Porges.
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 Good morning, Your Honors. Good morning, everyone. May it please the Court, Kelly Porges on behalf of Mr. Daley. I'm going to work backwards. That might be a little clear. With respect to what the fruit is, the judge's decision is abundantly clear. It's very clear from her findings of fact, the transcript, that the gun was not only discarded prior to the seizure, but there was no expectation of privacy.
So you have no problem with the gun being admitted at trial?
Absolutely.
What is it that can't happen?
The officer cannot testify that the person gave his name as TRAVAUN Daley, and I don't believe from the evidence presented and the video that the court will review that there is any world in which that officer would be able or allowed to point to my client and say, that's the person I tackled and saw run.
So that's it. I couldn't understand what you were saying. I thought maybe you meant since they couldn't have identified him, he shouldn't even be on trial. He should be off with his companions who also were never found again. You're not saying that?
Well, I don't think it's appropriate that an officer chased down a person and tackled them to the ground based on these facts. I think that's problematic.
I agree that if there wasn't reasonable suspicion, they shouldn't do that. But you're saying that what you think was ordered suppressed is an in-court identification by the officer. This is the person I tackled and arrested that day, and
Him identifying himself. And the person identifying himself.
yes, and him identifying himself. So let's now go, I don't know what happened later that day, but if I had to guess, he was booked.
That's correct.
Okay, so he goes into the booking place and they say, what's your name? I don't know that any of this happened, but likely it
It
did.
appears most likely he would have been identified at the scene. He was tackled to the ground, handcuffed, put in a police car.
Okay, but I'm just trying to figure out what can't come in, because there may well be plenty of other evidence of his identity that doesn't happen right then. So he's booked. Let's say he gives his name or shows his driver's license, and they have a witness who can come in and say, yeah, I was sitting at the desk, and this officer brought in Mr. Daley, and I asked him routine questions. Did you ask him his name? Yes. What did he say? He said Daley. Can that come in?
No, Your Honor. It's a fruit. It's flowing from the illegality of the police.
But isn't it inevitable?
Well, I don't think there's not some tenuous break in the illegal conduct in the booking. And the problem
But
is...
if they don't have to suppress him, they can fingerprint him. There's
It's
a
a
million
fruit.
things they can do to him,
The argument
right?
is it's a fruit.
And eventually, I mean, they could do it, I don't know where he is or what, they could do it this afternoon. You know, they could go and, oh, that's no good, we'll fingerprint him, we'll run it through our system, not including that day. I have no idea if his fingerprints were already in the system, but if they are, then we'll identify him that way, and that's what we'll put in.
The appellee's position is that would be a fruit. There is no break in the police illegality from the time you tackle him to the ground.
But wait,
Okay.
I just don't, he can be brought into court, and everyone has to pretend they don't know his name?
Well, Your Honor, that happens all the time in trials where someone's identified illegally or
The
unconstitutionally.
defendant comes in, and no one knows his name, and it's never presented, and the lawyer gets up and argues, ladies and gentlemen of the jury, someone committed a crime, but you haven't heard a single word from anyone saying that it was this person.
I gave that opening a week and a half ago, Your Honor. It's the government's burden
How'd it
to
go?
prove.
Yeah,
How'd it go?
how did that trial end?
I'm sorry?
How'd it go?
Well, there were other facts, Your Honor. But one of the elements is they have to prove that this person was the person. We frequently have cases where a witness's identification from a show-up or a photo array is suppressed, and when you look at Creighton and Collins, they are then not allowed to come in and say, oh, that's him. So I don't see a world respectfully
Don't
where,
those cases also say that the police officer can testify, this is the person I arrested?
if he's able to do that,
What do we do with the fact that at the motion to suppress, when the police officer was testifying about Miranda, giving Miranda, and then the ADA said, and did you ask him any questions after he was Mirandized? And then defense counsel objected, and the judge said, are you attempting to suppress the statements? I am not. So where defense counsel said at the motion to suppress that she wasn't trying to suppress the statements, did the judge even hold a hearing on whether or not the defendant's statements identifying himself as TRAVAUN DALEY came after or before Miranda?
So, Your Honor, I was the counsel on the motion to suppress. This is my case. And so what I made clear from the very beginning is it wasn't a motion to suppress statements where it was a Miranda issue or a voluntariness issue. It was an illegal seizure issue. And so if the government, I don't know how much more notice I could have put them on what I was attacking, and I was never attacking.
Well, you said identity, and I haven't been all the way through the transcript yet, but I've read the filings below, and you said in each of them, his identity, I think is the word you used, might have used identification.
Well, his
I have to say, I
name-
came in here, I thought you were saying no one is allowed to know who he is, he should have been allowed to run away, you'd never have found him, he should be released. I thought that's what you were saying.
In some, I am, Your Honor. If we're respecting the principle that people do not have to interact with the police, and he made it clear he did not want to interact, and then he
There's
was
case law,
tackled.
though, saying that illegally seized people are not suppressed.
He is not suppressed, but if the police officer got a much better look at him, being on top of him after tackling him, and then he was identified by giving his name, showing his license, just like the court said, booked and fingerprint, that is a direct result of the police illegality. If they let him walk away and respected his wishes, they would never have gotten his name.
Yes,
and
I
fingerprint.
understand. So they seized him illegally, according to you. There's case law saying he still goes on trial, right? He doesn't go free. I mean, it's not a game, right? We don't go around and say, like, I mean, how would we know if they would have ever found him? They didn't have to look. How, you know what I mean? Do they have to cover their eyes and let him go and wait 5 minutes and then go look for him again?
Well, they have to not tackle a person of color to the ground without any cause.
I don't know
That's
that there's
the starting
race.
point.
I don't know that there's race in the case. I haven't seen that you've argued that this was racially motivated, have you?
No, Your Honor, I'm just,
Okay.
we have the benefit of going through the motion with the video, so we're aware of certain factors.
The motion to suppress says that you're seeking to suppress a 9mm firearm and 4 plastic bags of white substance alleged to be cocaine
That was
seized
the-
from his person.
That was the prior counsel's motion, Your Honor? My motion was
Was there-
different.
So this motion to suppress that's in the record appendix isn't the motion to suppress?
It's not mine, Your Honor, no.
Is there a motion to suppress that you filed?
Yes.
Because there's a memo.
There's a memo, there's also a motion,
I
Your
thought I
Honor.
saw both, yeah, but I
Okay.
don't know where.
That was prior counsel's motion.
Was there any cocaine involved here?
I was subsequent counsel. It appears that there might have been cocaine involved, but nothing was ever charged, as far as I can tell. But again, I was the second lawyer. Not that I want to direct the court, I'm certainly happy.
What did your motion say?
Suppressing the seizure of Mr. Daley. I'm happy to also, if that was not in the government's appendix, I'm happy to forward that to the
No,
court.
I think we have it. Memorandum in support of defendant's motion. Wait, let's see who signed.
I see, this one that's in our appendix
Yes,
is signed by Osler.
This is,
That's
this
not
one,
me.
yeah, but this one, on 17
I
of the
wish.
record appendix is the one that council signed.
17? Is
Yeah.
that the motion or the memo?
That's the memo.
Yeah.
Oh, I see, I'm sorry, hold on. I was sure I saw the motion. All right, we'll find it if
We can
it's there.
probably pull it off the computer.
I'm also happy to forward it. I understand where the court's focus is, but I just want to touch on a few of the reasonable suspicion issues, which I addressed in my brief.
Please.
With respect to the be cool, the officer even spoke about this during cross-examination, that be cool could have meant talk to the police, be cool, don't talk to them. And with respect to the hands, the officers clearly stated Mr. Daley's hands were in front of his body. There was no indication of any bladed stance. There was no adjustment of his waist, and that is different from both Shane S. and Karen K., where those officers saw not only specific adjustments to the waist, a bladed stance. In one of those cases, they saw the person drop down and then ran freely, which indicated something was on his person before.
Are you seeking to suppress the gun?
No. It's just if the government is saying that the seizure also was appropriate, and my argument is that the judge ruled correctly and taken in totality, even all of these factors do not equal reasonable suspicion.
Tell me about popping up behind the Subaru. That's the one of these that I look at and think, what is that?
Okay,
Suspicion?
certainly, Your
You know,
Honor.
what suspicion does that raise?
So this was a situation where the court knows from the transcript that the officer saw 3 people jogging away, or excuse me, towards the shooting. They had no description whether the shooter or shooters was in a car, on foot, what race, what gender. They engaged in conversation. At one point, the officer states that the person later identified as Mr. Daley had kind of gone out of sight, popped down, and popped back up. He admitted during cross-examination that he could have been tying his shoe. There was nothing to indicate that that was dropping a gun. There was no hard metal object hitting the ground. And so that factor alone or in combination with the others does not give rise to the activity that the police engaged in at that point by chasing him.
As soon as he's tackled, the officer says to another officer, he squatted down next to the Subaru, go have a look.
That's correct.
So he must have had some suspicion that something had happened. I mean, he could have been wrong, of course, but some suspicion that something had happened at the Subaru.
One could say that was a hunch.
Well, one could, but one might say it was, at the low level, reasonable to suspect something, because he does seem to have suspected something. Now, whether it's disposal of a firearm right after a shooting, I don't know.
But right after, again, when you say right after a shooting, there's no evidence whatsoever to indicate that my client or any of his companions were witnesses, suspects, or someone who was shot at.
Well, if you're dropping something while the police are chasing you.
But this was before.
No, he was in his car following them. They were all fully aware that he was
okay.
there, right? And so if you dispose of something, we don't know what it is, but we have some suspicion maybe he left something there. Now, maybe it isn't a gun, but it's a gun or drugs or some other evidence of crime in all likelihood, right? You're not putting your art class sketchbook on the ground next to the.
But the officer didn't see him put anything down. The officer admitted during cross that he very well could have been tying his shoe.
No, but reasonable suspicion includes less than 50% chance, even. But let's say it's whatever. Of course, there are other possibilities. Lots of times, searches turn up nothing, but we want to make sure that they're legal. We don't. That doesn't excuse it. But they do turn up nothing because, in fact, there was a chance that it was something else, and it was, or nothing at all. We see lots of those.
But the trial court carefully factored all of this in to her decision. She factored all of the things that the Commonwealth just listed and clearly stated that on their own or as a totality, she's thinking about all of them, and still it was not enough. The government is not contesting the factual findings. They're contesting the.
Did the police have to have reasonable suspicion that your client and the gun was the source of the shot spotter shots? Or would it have been enough that the police and presumably your client heard the shots, and then this ensued, and from the defendant's, your client's behavior, including the ducking down behind the Subaru, that might have given reasonable suspicion?
So I think no matter how the court looks at it, whether you're thinking, did he have reasonable suspicion to believe my client was armed, and/or did he have reasonable suspicion that he was in part of the shooting? Neither was present. If you look at just the fact, did he have reasonable suspicion that Mr. Daley was armed? Absolutely not. If you take it out of the shooting context, there's no bladed stance, there's no grabbing the waistband, there was no description of anyone with a firearm. If you look at it in the context of...
And if he's hidden the gun, then he's not armed anymore. If what you think he did when he squatted down was hid the gun.
There's no reason for the police officer to have chased him down and tackled him. I guess that's where my focus is. The police are allowed to engage citizens, to ask them questions, to investigate cases. We want them to do that. But we don't want them to basically jump to conclusions and chase and tackle someone. The government's argument is the reason he was chased and seized was because of those 5 factors. And
When we're thinking about what it is that the defendant moved to suppress, does the SJC's recent opinion in De Los Santos change our analysis, where they abrogated Mubdi and said the defense now, the Commonwealth no longer has to clarify what it is being sought to suppress. If the defense motion to suppress doesn't make clear what it's seeking to suppress, the Commonwealth doesn't have to present evidence on that issue?
So, no, Your Honor, respectfully, because I made it abundantly clear at each step of this game what was being suppressed.
The gun and the cocaine is what the motion says.
That was not my motion. Again, I filed a subsequent motion that was very clear. Again, I'm happy to provide that to the court if it wasn't in the record appendix from the government.
Please do.
That was prior counsel.
Can you do that, please?
Absolutely. So my argument at my hearing was very concise. My motion and memorandum was very clear and concise. The judge's ruling was not only correct, but it was also clear and concise. And if the government was confused by her ruling, the appropriate remedy could have been to simply file a motion to clarify. That was not done. I believe that all the pleadings are very clear.
Your time has expired, and I see no other questions. Thank you also for an excellent argument. Very interesting and unusual set of facts. So thank you both. The case is submitted.
Thank you. Have a good day, everyone.
You too.
Our next case is number 23-95. This is Commonwealth versus Garami. And we will hear first from Attorney Peterson.
May it please the court, Jennifer Peterson on behalf of the defendant appellant Kamal Garami. Your Honors, this is another case of the prosecution wanting to have its cake and eat its cake and have it too. Here the defendant wanted to introduce police reports, the content of which included that he had been threatened by the complainant's brothers for refusing to continue on with an arranged marriage situation. And defense counsel wanted to introduce it to show alibi, to show the context of the parties' relationship, and to show that the complainant had reason to concoct these claims against the defendant. The Commonwealth moved to exclude them and was in part successful in excluding these 2 police reports, but then the Commonwealth turned around and used the issues contained in the police reports in its closing argument to suggest that things that it knew that it wasn't true. So what the police reports were about, Mr. Garami was a long-haul trucker, and he had called to report to the Revere police that he had been threatened by...
That's not in the record, right?
Which?
The earlier call, it was not presented to the jury at
The
trial.
earlier call, no, just the one police report was
I mean,
presented.
you're describing facts, but none of this is in the record.
Well, it's in the motion in limine.
Okay.
So,
Were the police reports that are in the record appendix attached to the motion in limine, or were those just obtained from the defense counsel's trial file?
I'm uncertain, but they were referenced, and the parties discussed both of these police reports at the motion in limine. And
But were they in the record before the judge?
I'm uncertain if the judge had a hard copy of it, but it was discussed in front of the motion, the hearing judge. So it wasn't just a single thing. He had called up, and even the police reports themselves, I believe, make reference to the previous, I'm uncertain of the phrasing of it, but there was testimony that Mr. Garami, and it was discussed, that he had called the Revere police while he was on the road to report these threats that were being made by the complainant's brothers. He was instructed by the Revere Police Department, you need to come and make a report when you come back into town, because you're not here right now. So he did. He came back as soon as he got back into town, and the police report that was in front of the jurors references that,
Was that in front of the jurors?
The police report?
Yeah.
The content of the police report was not in front of the jurors. No. The fact that he made the report was in front of the jurors, and they allowed the fact that Officer Breens was allowed to testify that Mr. Garami came into the police station at a certain time, which he estimated to be 3:45. Originally, he estimated it to be 4 a.m., but he changed it to 3:45. A report was made that Mr. Garami was at the police station, and so the trial judge allowed it to be used as evidence for essentially alibi
Yeah.
purposes, but would not allow the content of what he said, which was that he was being threatened by the
Are you
complainant's
saying that the
brothers.
police reports, the documents should have come into evidence, or that Brennis should have been allowed to testify to what the defendant said the victim's brothers said?
Either or, but I think the argument was that Brennis should have been allowed to testify as to that.
Why isn't that multiple totem pole hearsay?
Well, I think it's a bit of a red herring to call it hearsay, because it's not really there about this isn't about the brothers, it's not about the threats. This isn't being offered for the truth of the matter asserted. This is offered to show that the complainant had a motive to lie in this case.
Yeah, but if it's false, she didn't, so it's being offered for its truth.
I would disagree. I would suggest that it's being offered to show the context of the relationship.
Yeah, but if he's lying to the police, then she has no reason, this isn't actually a reason why she would resist him or fight him or claim to have been raped or, right? I mean, if it didn't happen, if he didn't break off this engagement or whatever it was, arranged marriage, then he doesn't have an alibi, or alibi is the wrong word, right? He doesn't have this arguable defense.
Well, I would suggest that the Commonwealth is allowed to make a case where it's suggesting, she gets up and she testifies, this is my husband. And it's not until cross-examination that it comes out that she had just met him a couple months before. They met in Algeria, and it was arranged by her sister and her parents to meet him, that she said that they married in a religious ceremony. They weren't married according to Algerian law. And then he left. He was just visiting Algeria. He came back here. She came over to visit him, and after she visited him, she was with him for a couple weeks and then went to go live with her brother.
But she didn't testify he cut off the arranged marriage.
No, she didn't. And defense counsel was prohibited from talking about those things. She couldn't, and she even says at one point when she's cross-examining her, okay, I'll move on, because she wasn't allowed to inquire
Defense
about.
counsel tried to ask her, isn't it true you were angry because my client ended your marriage or your relationship?
She did. She did. She brought up, and she said, and the complainant said that they had disagreements, that they hadn't broken off. She came, she visited, she was with him in his truck for a couple of
So
weeks.
she denied the truth of what he said in the police report, or she didn't speak directly to the question of, was he going forward with the arranged marriage or not?
No, there was no discussion of no discussion that she is the one that wanted citizenship.
Counselor, you just told us that in cross-examination of the victim, defense counsel tried to elicit evidence about the relationship. And I'm not seeing that. The only objection I see is to the question of, doesn't it get more violent every time you tell the story? So I'd like to know where in cross-examination the defense counsel was prohibited from asking the victim about these things.
And it's an inference that she was moved on because she was told, and she objected later on. There's two different parts in the record. One, it is on page 90 in volume 1. She says, so when you describe Mr. Garami as your husband, that's not legally accurate, is it? She said, maybe in this side, yes. And then she said, I'll move on. And so.
Okay, but that's not, the judge didn't tell you to move on.
No, the judge didn't. But I'm presuming, especially in light of the fact that defense counsel later on, after the jurors came back and said, can we see this police report that he filed? Can we see it? And the judge denied that request. And the defense counsel renewed her objection to not being allowed to cross-examine on this. And she said that, I'm renewing my objection now. This is why I should have been able to do this. And that's in volume 2. I don't have the page in front of me. But defense counsel renewed her objection about that.
I renew my objection to the court's opinion that you know that is not relevant, the police report being not relevant. I don't see where she's renewing an objection, which, as you admitted, she never made.
She wanted to introduce the police report. She
Right, but
wanted
there's
to introduce
no,
the contents.
not
of the police
renewing an
report.
objection to being forbidden to try to elicit this from the victim.
I think that is what she meant by that, so.
Well, but if she's renewing an objection she never made, why is that a valid ground of appeal?
There were objections made during the motion in limine as well, Your Honor. There were objections made to not being allowed to counter the fact that the Commonwealth, and especially, even assuming everything was right, as far as this goes, during closing argument, the Commonwealth suggested, and it literally said, that I would suggest to you that the defendant went to the police revere department in advance, knowing that when he came home, he might have to choose violence, because that's what he did. Planned it in advance, all right?
Was planning in advance an element of the crimes that your client was charged with?
I don't think so, Your Honor. I think that what she's suggesting, and the Commonwealth knew that he had called in to report this. The Commonwealth was aware that he had been told that he needs to come by in person when he gets back into town to make his report. And he even said to the police, they said it in the heat of the moment. So I would suggest that the fact that it isn't contained, that in the heat of the moment, that's when they learned while he was on that trip away, that they learned that there was no way that he was going to marry her. She wasn't going to get citizenship. They were angry about that, and that's why the threats came up. And he said, now that it's not the heat of the moment, I'm not worried that they're going to carry through on
Is
these
there
threats.
evidence that this was a sham marriage that was designed for immigration purposes? I mean, you just said that she wasn't going to get her citizenship. I don't remember seeing that in his phone call.
She didn't testify to that, Your Honor.
I don't remember seeing it in the
wh-
police report of his phone call.
I would assume he did not say that, to the best of
So
my knowledge.
there's nothing
to
in the record
police.
about immigration at all?
There's nothing to say that anything except for this. They referred to it repeatedly as an arranged marriage, and only by religion. And she came here to visit him. And she was only with him for a couple of weeks, actually, just a couple of weeks. She went to live with her brother, and then she didn't come to to live with him, even though she calls him her husband, until February, when he was gone for several weeks in February trucking, because they had an arrangement that he could live in the apartment while he was gone.
Counselor, this statement the prosecutor made, that the defendant planned in advance to batter the woman, so therefore decided to check in with the police first. It's so preposterous that I would like your best argument that it's a substantial risk. The jury could have done anything other than just disregard this.
I don't think the jury could. The jury didn't know. It's improbable, as Your Honor suggests, that Mr. Gami would go to the police prior to going home and assaulting his alleged wife, who wasn't the wife, who was just somebody staying there that he knew for a few weeks. They'd literally known each other only for a few months, most of which they weren't together. So it is, and jurors came back with questions. And the jury came back, can we see, first of all, they asked to be re-instructed on 2 of the 3 counts, and one of which was found not guilty. And then, and it's also, I think, kind of relevant to point out the fact that she never claimed that there was any indecent A and B until about 6 months later, after the fact. Those charges were brought. And the Commonwealth would have you follow this narrative that she is, a victim, she's 25 years younger, but she's a 37-year-old self-determinative woman that traveled to the United States to visit this man that she said she was in, a marriage with as a result of a religious ceremony. She admitted, though, in cross, that she wasn't married to him legally in Algeria, she wasn't married to him here, and the Commonwealth was allowed to suggest to jurors, and I would suggest mislead jurors, that he was somehow taking advantage of her. They talked about that he was a predator, that I think the prey was the word that they used, and entitled to treat her like this.
I have a question for you back on the motion to eliminate issue. At the hearing on the motion to eliminate, there was discussion about the fact that Officer Brennis had said over the radio, "Heads up, the man that lives at that address was just recently here 20 minutes ago filing a threats report." So she may be saying this to cause trouble. I understand that the defense argued at the motion to eliminate that should have come in, and the judge rejected that argument.
Yes.
I don't see that argument in your brief on appeal, so I understand you're not making that argument now?
No, I don't believe Officer Bren's, it was his opinion that she may be trying to cause trouble. I didn't see a way of appropriately raising it, like legal footing, just to give his opinion that she may be causing trouble. However, I think that's kind of indicative of what the Commonwealth knew. The Commonwealth was aware that there had been a previous report called in, there was a second report, and that this wasn't that he just on the spur of the moment decides he's going to assault this woman and stop by the police station to come up with a nifty excuse for, an alibi for why it was he wasn't where he was. And the whole idea of parking a truck, getting from the Revere police station and then going and parking a truck and then racing up to his apartment and assaulting her. And there was also a question, and I raised it in my brief, I pointed out where it was in the record, that one of her brothers may have been there at that time. So I think that this case, fundamentally it was unfair. Mr. Gami couldn't raise his, mount a complete defense. He was precluded from showing jurors why there was a credibility issue with this complainant.
Okay.
And that's really what it
Your time has expired, but if there are further questions, I see none. Thank you for a very good argument, very helpful to us.
Thank you, Your Honors.
We will hear next from Attorney McLean.
Good morning, may it please the court. Ian McLean on behalf of the Commonwealth. Your Honors, before I begin, I'd like to acknowledge and recognize Claudia Tomasini, who was on the brief and is watching the live stream but couldn't be with us here today. Your Honors, beginning with the Revere police reports, the content of the Revere police reports was classic hearsay. The argument that I just heard from opposing counsel was that it was admissible for 3 reasons: alibi, context, and bias. I'll just take them in order quickly. As to alibi, you don't need the content of what was said during the report to establish the when and the where it was said, which is the only thing that would be necessary for alibi. And the judge did not preclude that from this trial, despite the fact that the defense did not provide an alibi notice of that defense. So that's not a basis on which to admit the content of the reports. The second, bias. Your Honor, as you pointed out during the argument, it would only be relevant then if it was in fact true, if it was being offered for the truth of the matter asserted, which again would make it classic hearsay. So again, we don't have an exception on which to admit this classic hearsay. Third, context in their relationship. That's not a recognized exception to the prohibition on hearsay. I didn't hear arguments about verbal completeness or the constitutionally based exception, but really briefly, it doesn't satisfy either of those. This case basically is Steve's, which the SJC just released, I think, last year, where there's a significant break in time between the two conversations. It's not a single conversation, so it doesn't
Okay,
satisfy.
so let's say we agree with you that this report is inadmissible and there's no error in the motion limine. So through excellent lawyering, the Commonwealth has gone in and has gotten this police report out of evidence. All the jury hears is that he stopped at the police station. He could have stopped because he had a car accident. He could have stopped because his dog was lost. He could have stopped for any reason in the world. They know nothing about why he stopped. It's just part of the narrative of what he's doing when he ends his trip, I guess. I mean, I don't know why it's even relevant if the contents can't come in, but whatever, it comes in. They have no idea what happened. Then in closing, the prosecutor says, now I would suggest to you that the defendant went to the Revere Police Department in advance, knowing that when he came home that night, he might have to choose violence, because that's what he did, planned it in advance. Okay, so now I'm a juror. I've been thinking lost dog. Maybe that's not, maybe you don't report that to the police, I don't know, but I've just been thinking, whatever. He stopped at the police station. Now I'm being told by the prosecutor, who actually knows, but who may know, that really, whatever it was designed to make it easier for him to have some argument that if he used force, it was permissible or justified, or if she claimed it, she was lying, whatever. The jury then goes, they deliberate, and eventually they're like, and they ask this question: can we see the police report? Presumably that's because they're discussing what it might have said. How can we say no substantial risk of a miscarriage of justice if we find it's error to do this? And I'm not sure, since none of that is in the record, that, that's sort of the argument here. How can we say it wasn't a substantial risk of a miscarriage of justice?
Well, it's three things, Your Honor. First, I'd say it wasn't an error. It was arguing for an inference and in response to the defense's close. So I want to circle back to that substantively. Second, there was no objection at the time. As you pointed out, we're talking about substantial risk. So we can infer something from that there wasn't anything that objectionable about it.
Every substantial risk case has no objection at the time.
Of course, Your Honor. Of course, Your Honor. And then the third reason I point to the lack of any prejudice here is the jury acquitted the defendant of the top count. He was acquitted of strangulation.
But that's not, I've never understood that. This isn't designed to overwhelm their sense of doing any justice. It focuses just specifically on, did he plan in advance to use violence against her? And he was convicted of using violence against her, not strangulation. Although I think if we look at the record, we'll see that there's, the strangulation piece of it is evidentially sufficient, but not the strongest of the three charges. But he is convicted of 2 counts of doing violence on her. Tell me how it cannot be error. I also don't, you say it's an inference. I infer that because he went to a police station, he must have had a plan to use violence. I don't see how that's, without knowing a little more, how that's a good inference.
Well, Your Honor, it may not be a good inference. Maybe it's not a particularly strong inference, and maybe that's why the jury acquitted him of the top count of strangulation. I'd also remind you that the jury was instructed here, both at the beginning of the trial and after closings, that the closing arguments are not evidence. So,
sure, but then they asked about, now, we don't go behind jury verdicts, blah, 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 we do lots of times. Actually, for example, the acquitted of strangulation. Let's look behind the jury verdict. What does that mean? So let's look at this. They asked about it. I know they're told it's not evidence. Maybe that's why they're asking about it. They'd like to see it.
And respectfully, Your Honor, they're presumed to have followed the judge's instructions. So here they didn't take the closing argument as evidence. Now, it may not have been a particularly strong inference, but the inference that the prosecutor was arguing for, which he clearly made at the beginning of the statement, which you just read, which is, I would suggest to you, indicating to the jury, I'm asking you to draw an inference. Asking you to draw an inference. Maybe it's not a strong inference. The inference was...
I don't think it's a reasonable inference.
Well, and the jury clearly didn't accept it because they acquitted him of the strangulation charge.
Strangulation isn't what this is about, but all right.
Why-
What's the reasonable inference, and why is it reasonable?
Well, the inference that she was asking the jury to draw was that he was executing a plan. Now, indecent A and B actually have intent elements, and the jury was instructed about that intent element. So he was executing a plan here. He went to go try to create an alibi for himself so that he would have something to fall back on when he executed his plan, because he knew that his plan of sexual relations with this woman that he had a strained relationship with might not go well. So he was beginning to create some sort of plan against it not going well. Now, it may not have been a strong inference. I mean, I would suggest it wasn't a particularly strong inference, but she made it clear that she was asking them to draw an inference with her, that he was executing a plan.
You think the inference was he was creating an alibi?
Correct, Your Honor. Correct, Your Honor. And clearly it wasn't that strong of an inference because they ultimately acquitted of the top.
Of strangulation and the evidence, I'm trying to remember, because the case isn't about the strangulation count, but I feel like there was, a doctor couldn't say that it was strangulation or whatever the requirement is for strangulation. Like the evidence was just, I mean, like I say, it was sufficient, but it wasn't like clear.
It didn't get beyond a reasonable doubt, Your Honor. So, I mean, they basically
Okay,
had
but
the
I don't
victim's
see what that
testimony.
has to do with creating an alibi, so.
They basically had the victim's testimony and then nothing really substantial from either the photographs of her that were admitted into evidence or the medical records to substantiate it. So the jury decided to acquit on the top count, strangulation.
If he had stopped at a bank and she had said the same thing, would that be okay?
Absolutely. The argument there would be banks have video cameras and such, so he's beginning to try to create some sort of alibi.
You think the alibi is, I wasn't even at home?
Correct. Correct, Your Honor.
That's not a very good alibi for someone who's doing an assault in a building and the police are going to come in 2 minutes.
Well, Your Honor, I'd respectfully suggest that at 4 o'clock in the morning, you're not necessarily going to find somebody that's going to corroborate you were somewhere in a different location. So here, a police station was open at 4 o'clock in the morning, so we went to the police station to create a report about something, to establish a time and place where he was, on the possibility that he needed something to try to discredit her in case it goes wrong when his plan falls apart. So it may not have been a strong inference, Your Honor, but it was a reasonable inference, and it was made in response to the defense closing, which opened with, don't believe her, he has an alibi. So she was asking for an inference, she was letting them know that it was an inference, and it was in response to the closing argument that was made by the defense. Further, the judge instructed the jury that closing arguments are not evidence, both at the beginning of the trial and after the closing argument itself, and they're presumed to have followed those instructions. So here, this doesn't rise to the level of a substantial risk, particularly where the jury decided to acquit on the top charge. If there are no further questions.
I see none. Thank you for an excellent argument.
Thank you, Your Honor.
Both of you. Very helpful to us. And the case is submitted. The next matter is number 23-484, and that is Commonwealth versus Sabin. We will hear first from Attorney DeMeo.
Good morning. May it please the court. Christopher DeMeo for Robert Sabin. So we have two small issues in this case, one concerning the parental kidnapping statute and one concerning authentication. The parental kidnapping statute reads, in relevant part, whoever being a relative of a child less than 18 years old without lawful authority holds or intends to hold such a child permanently or for a protracted period shall be punished. So the question here is, I guess there's two questions. Is this the kind of standard that the court can step in at a certain point and direct a verdict for the defendant? And if so, is 6 days okay or not okay, as we say here? Because the record shows that Mr. Sabin was going to take his son to New Jersey for 6 days, and the police got involved, and he ended up holding him for about 5 hours over what the
Do we know how old the child was in July of 2020? I can see from the record that he was 7 at the time of trial, but I can't tell
I think it says 5.
Okay.
I think I saw 5 somewhere in that range. I think everyone agrees that protracted means for a long time or longer than usual, so it's sort of a subjective where you draw the line. But the argument here, which I think is a little problematic, that the prosecutor made was because he's supposed to return the child at 6 o'clock or 8 o'clock or whatever it was, and he was late, that's unusual. That's longer than usual. Therefore, it's protracted. But the problem I have with that is there's already a separate requirement that it be unlawful. So if that were the case, then every time you kept a child beyond what your custody order said, that would be longer than usual and it would be protracted, even if it was just an hour or 2 hours, which I don't think this court should go that way, or else you'll be seeing perhaps a lot of sort of minor custody dispute kind of issues coming into the criminal
Well,
side.
after discussion at the charge conference, the judge instructed that protracted means drawn out, prolonged, longer than usual. Do you have a problem with that instruction?
I don't have a problem with that instruction, no. I mean, I guess it kind of...
Wait, so but why isn't this longer than usual? It's obviously longer than usual.
Because the question is, what is the protracted period? And I would say the permanently or protracted unlawful...
The instruction that you don't object to has longer than usual in it.
Yes, longer
So
than
they
usual.
were instructed longer than usual. Let's say they found, he usually only gets 2 days, even if we pretend that these days that are not his, he could take the child for 2 days, because that's usual, or at least the usual length. 6 is 3 times that. That's longer than usual.
Because you would always, then the Commonwealth would win every time, because by hypothesis, it's an unlawful holding. There's 2 separate requirements: without lawful authority and holds the child permanently or for a protracted period. So by hypothesis, he's kept the child longer than he's supposed to because it's without lawful authority. So if that were enough, then what would be the point of the permanently or protracted period?
You seem to be attacking a straw man here, though, because the evidence here wasn't just slightly longer than usual. The evidence here was 6 days where it's normally 2 days. So why couldn't a jury find that was protracted?
I mean, it's a parental kidnapping statute. So I realize that there's a whole range, but when you look at the cases we cite, it's people taking their kids to Saudi Arabia or secreting them off somewhere. This was, at the end of the day, the court may say 6 days is fine, but it seems to me you have to draw the line somewhere, or else you can't. The Commonwealth's argument that if it's unlawful, then it's longer than usual, because usual is obeying the law, then there would be no limit. It could be an hour late. It could be 2 hours late. It would all be a jury question. And if that's what the court wants to do, I'm suggesting this case, like lots of other cases where you have a whole spectrum of, we cite negligence, material breach, whatever. There comes a point where you have to cut it off.
But as you say, it's a jury question. What if this child was a year old and was still being breastfed?
Yes.
Wouldn't an hour late be protracted?
I agree, yeah. I agree, it does depend on, but there was no, I mean, the evidence here showed it was the summer, he wasn't in school, he had no medical issues. It was, and protracted, I would say, I'm not objecting to we don't object to the jury instruction, but protracted does have a sense of, you don't know when it's going to end and you're anxious.
It doesn't say indefinite. It doesn't say for an indefinite period, right?
It doesn't say it, but I'm saying when you say protracted negotiations, it's like when was it going to end, or protracted litigation. I'm just pointing out you don't have that here. I mean, this was something that was communicated months ahead. She didn't, certainly Ms. Castro didn't agree with this, and she said that in the text that was entered, but this is not a case like other cases where there's that element of uncertainty. So I think protracted does have a connotation of indefiniteness or uncertainty, which you don't have here. You don't have a sickly child or a breastfeeding child, a child in school. You don't have any, this seems to me to be a run-of-the-mill kind of a family law kind of a case that got blown up into a criminal case. But I don't know, there's a lot to be gained by talking about. I mean, you have to cut it off somewhere in 6 days, 5 days, 5 hours. So I'll move on to the authentication issue unless there's, the authentication issue is really just, we don't think that the prosecutor could authenticate the custody order here like it was done as if it were a photo or an email. It's enough to say, normally it's enough just to say that's what it purports to be, and I recognize it. There's a specific statute here that, as I read the Duramo case, has to be followed.
Well, so the Duramo case, after talking about why the document wasn't properly authenticated, which it wasn't, then on page 49 says, whereas here the parties and the judge had themselves compared an authenticated record with a copy, the copy may be admitted to the extent it is identical to the authenticated document, and then adopts proposed rule of evidence, which I assume is now real rule of evidence, or guide evidence, 901B3. So it seems like the Duramo SJC, and then they hold it's harmless because everything but the one part that wasn't identical was fine. So doesn't the Duramo case say that there are ways other than certification to get in a government document?
No, I mean, clearly there was no prejudice there because there's a huge footnote of all the other.
But only because most of the document, even though none of it was authenticated, was admissible because it had been compared.
But that was just a peculiarity of that case. I mean, in that case, there was a properly authenticated and attested to copy of the docket that contained like A, B, and C that the Commonwealth wanted to prove. And then there was an unattested to one that contained A, B, C, and D. And so the question was, does the fact that you don't have D in the official one, what does it matter?
I get
it
that,
didn't matter because you had
why
A, B,
isn't it the case that Duramo's telling me there are ways other than certification by the record holder to get in government documents?
I cited the part.
It says on 49. And you don't have to accept that, but if you do accept it, I'd like to know why you think this isn't one of them.
So I'm on page 49. I'm sorry, what is the...
Whereas here the parties and the judge had themselves compared an authenticated record with a copy, the copy may be admitted to the extent that it is identical to the authenticated document. See proposed rule of evidence 901B3. Authentication requirement may be set aside through comparison by the trier of fact or by expert witnesses with specimens which have been authenticated. And then they go on to say everything but the part that didn't compare was fine.
Right.
And therefore it's not
I mean, that's
harmful.
my answer. I guess that's what I just said. They had an undisputed attested to copy that overlapped in substantial part, so there was no issue with that. I don't read this to say that...
We don't have a certified copy at all,
No,
right?
you don't have this at all.
All right, so let me ask you this. I know you have no burden, of course, at trial. You're the defendant. You have to show prejudice here, and I'm not sure how this works in light of the burdens of proof. assuming, well, you haven't shown, I'm not saying it's your burden because I don't know, they haven't shown either, that the certified, that a certified copy will be any different from this.
That's true.
So we send this back for a new trial because it wasn't properly authenticated. We hold the same trial we just did, at which the same document is put in, except there's a signature that's not a Xerox, it's the signature. Now, maybe you'll luck out and the outcome will be different.
I'm not prepared to say that because I don't know. I mean, I was curious, so I just wanted to see if I could pull this up on mass.gov, and I couldn't find it, so I'm not going to, this begins with there's like a 2017, what's in the record has a 2017.
All right, so let's say we vacate and remand, and the judge asks before the trial starts, do you actually have a certified copy of this order that's supposed to be so critical to your case? And the prosecutor says, why, yes, Your Honor.
Yes.
And she hands him the thing, and he looks and he says, this is the same as the one I showed them last time.
Well,
Well, wait, do you think you get a new trial, or is that a no prejudice situation?
no, if you,
Say again?
so your question is, rather than setting aside the verdict, I'm not sure I understand the question.
Well, I'm just asking,
Because
you may be structural, like, if there's no competent evidence of this order, then you'd be entitled to a new trial, right, ordinarily. But in this case, there's no competent evidence, but the evidence that was in is literally identical to the competent evidence, which I'm not saying it is, do you still get a new trial?
I think so. I mean, that's why I went through some pains to cite in the Duramo case all that stuff about we adhere to this rigidly and it's not a formality and so on and so forth. So that's, and then Mr. Sabin would get another chance to argue that 6 days is not prolonged or whatever, and I guess that's the price the Commonwealth pays if they don't authenticate things properly. That's our position. And I will just say that Duramo, again, if you look at footnote 13, there's a huge list of why there was no prejudice in that case, because he had been, I think it was an OU, I can't remember, but he had been dealing with the RMV for a long, long time, and the question of notice, there was a lot of evidence that he was on notice, and you don't have that here.
There might be a best evidence problem. But if a witness said, oh, I carefully read the court order. No one's presenting even a Xerox, whatever. You did, and what did it say? Paragraph 2 said, every other weekend and Wednesday nights, or whatever it is.
Well, Ms. Castro said that, and there was no objection, but by that point, the exhibit was already in evidence.
Yeah, no, I get that. I'm not saying you had to.
It seems to me the Commonwealth's best argument is that when the cop pulled him over, he apparently said something about I'll deal with the contempt later, and that's so. But in my opinion, that's not really. What does that mean? I'll deal with the. It's like, my child's mother's mad at me. She's going to drag me into court. I'll deal with it later.
Well, he did state to me that he knew he was in violation of the order.
Yeah.
That'd be some evidence of that.
Yeah. So that's the best, that's the best if you were going to find no prejudice. But it seems to me if you compare this to the Duramo case where there's just a whole slew of evidence that supported the thing that was in the unattested to document, they don't really compare.
It's a weird problem.
If no more questions, I will rest there. Thank you.
I see none. Thank you very much. Excellent argument.
Thank you.
Can you give us just a minute? I'm sorry. Let's deal with this during the break. All right.
Thank you.
Of course, we're going to
We're going to have to discuss this.
Yeah, we're going to discuss this and then. Sorry for the interruption. We will hear now from Attorney Black.
Thank you. Good morning, Your Honors. Johanna Black on behalf of the Commonwealth. I'm just going to start with the statutory interpretation issue of the case. The Commonwealth laid it out as to why Your Honors should affirm the trial judge's definition and instruction with respect to the term protracted period of time in the statute, section 26A of 265. The Commonwealth provided Your Honors with a letter from the petitioner behind the bill to the governor that sets forth the reasoning behind putting forth this law. I think that is significant to Your Honor's interpretation of the statute, especially where the word protract.
Why would that be significant? Why would it matter what the petitioner thought? Doesn't it only matter what the legislature thought?
Well, the petitioner being part of the legislature, the governor being part of the legislative process and enacting a bill, it is a piece of legislative history that tells you what the legislature was thinking when they enacted
Doesn't
the
the
bill.
words of the legislation tell us what the legislature was thinking?
I'm sorry, could you
Isn't it
repeat
the
that?
words of the legislation that tells us what the legislature was
The
thinking?
statute itself?
Yes.
Yes. So what I was saying in the brief is that, or what the Commonwealth says in its brief, is that the term protracted has an ordinary, common use associated with it, so that you can allow that definition to, you can use that definition to interpret what the legislature meant in using that word in the statute. Even apart from that, I do want to bring up the fact that defense is arguing that it's a general term, that it can encompass a lot of different circumstances or scenarios. But even when that's the case, so for example, the case of McCarthy versus Commissioner of Revenue, I didn't put it in my brief, but the site is 391 Mass 630 from 1984. And a more recent SJC case, Commonwealth versus Angel Perez Narvaez, from 2022, and I just have the SJC number, which is 13275, goes on to explain.
Could you give me that number again?
Sure, the SJC number?
Yep.
13275.
Okay.
So in reading these cases, the Commonwealth would suggest to Your Honors that when Narvaez is explaining the McCarthy case, it talks about the term any person in the relevant statute in McCarthy being susceptible to different meanings. There was an argument that it was an equivocal word with no fixed and rigid signification, which is similar to the defendant's argument in this case. And the SJC found, because of that, even though you can define the term any person, where it can be equivocal, and there's no fixed and rigid signification of its use in that context, you can look beyond the statutory language, the plain language of the legislature's words, and look at the legislative history.
It is certainly true that in Massachusetts, when there's ambiguity in language, the SJC has said that you can look at legislative history.
Exactly. So here, although the Commonwealth is saying protracted has a plain and ordinary meaning that you can simply use, even if you disagree and find it could be ambiguous.
How does longer than normal work? Isn't 1 minute longer than normal?
1 minute can be longer than normal.
Of course.
That's right.
So any period of time is protracted. It's unlawful.
That's why the defense is arguing that it doesn't have a fixed and rigid signification.
I'm asking you.
Well,
The judge said, I mean, I'm not saying that 6 days is a minute. It obviously isn't.
right.
It's not an hour. You know what I mean? It's not the same evening, whatever. But if it's always longer than usual if you have the child unlawfully, because the usual thing is to only have the child when it's lawful.
When you're allowed to by the court
Yeah.
order. So the Commonwealth's position is you don't have to decide that today. But even if.
Well, we do,
But even
actually.
assuming, well, the 6 day, that's kind of a vagueness issue or argument, and the record doesn't present that as an issue you can resolve today. And as you know, constitutional issues you don't even reach them until you've interpreted the statute.
This isn't a constitutional issue.
Well, it's the vagueness. You're concerned about the notice, right? When you're saying
No,
it's
I'm not
general
concerned
and it
about
can-
that at all. I'm concerned about making sure protracted doesn't mean any length. And once you say longer than usual in this context, I don't understand there's no objection to the instruction. I'm not really talking about the instruction. It seems to me an hour is longer than usual. I mean, I guess you could, I don't know if you're supposed to look at extrinsic circumstances. Your brother said yes, but I don't know. There's a terrible snowstorm. I'm going to be 30 minutes late. It is longer than usual. But I don't know. Maybe we'd say, well, when there's a good reason, it's not, whatever. But it's, but it's always longer than usual.
I mean, we're going to have to write an opinion, and it's probably going to get used for a model instruction.
Right.
So if you really think our opinion should say longer than usual is what protracted means, you'd best give us some more argument for that.
So the Commonwealth is just asking that you decide the issues based on the facts of this case and not go beyond what's necessary. But in taking up your concern about the 1 minute, the Commonwealth always has to prove that someone intends the act, that they intentionally committed the act that
I'm
constitutes the
intentionally
criminal
keeping the
offense.
kid for an extra 5 minutes because the cartoon isn't over yet. It's
so-
intentional.
Right, so with your first example, when there's a snowstorm, there's the
That's
defense of
intentional,
an
too.
accident. If you're driving and the traffic's longer because of the snowstorm, that would be pretty
I
difficult
guess
for
it
the
depends
Commonwealth
when you
to prove.
realize it's snowing. You know what I mean? I don't know.
Right.
Yeah.
Well, so I think it's important to recognize that the Commonwealth is always under an obligation to prove, and, we're not going to take out charges if we don't have probable cause or good faith belief that they intended the act
Of course,
which
we hope
constitutes
not,
the
but the
offense.
judge has to be able to enforce that.
Right. And so you can't prove this crime without them intentionally committing the act. And so then that brings into all the circumstances, because circumstances of an offense are relevant to a defendant's state of mind and intent. So, I know you're giving a 1 minute example, but I'm just going to jump to 90 minutes. Because
Okay, 90 minutes is good. Let's go.
Might not be, a big deal in some circumstances. Say someone's running late, they're not someone that takes the kid beyond their entitled hours or their lawfully granted hours by the court, and it's kind of a one-off, and you're not concerned about the safety of the child in that person's custody. That's a very different situation and may not qualify as protracted than a situation where someone just took a child or held them for 90 minutes longer than the court order allows them to, and they're someone that either has a violent history or there was domestic abuse, or in this case, it didn't come into evidence, but there was statements by the attorneys that the complainant had alleged that the defendant had sexually abused his child, the child at issue, and also had made child pornography
As you say,
involving
it's
the child. So
not,
90 minutes.
that's not in the record.
It is in the record. They
I
discussed it
thought
at
you said
sidebar.
it was not in the record.
It's not in evidence at trial. They discussed it at sidebar during the trial. So it's in the record on appeal, but it's not
It's
in
not
evidence at
evidence, though.
trial. But so just 90
I
minutes.
still, I have to say, and maybe it is protracted, I assume that there are lots of parents with joint custody, maybe most of them, where if you're 90 minutes late returning the child, the one who is not, doesn't know where the child is or hasn't been, or does know but is entitled to the child back, will be enraged. 90 minutes seems to me, 6 days, 1 day, of course, it's in violation of a court order. But then there's these words about protracted. You know what I mean? I don't know.
Well, protracted does have kind of a subjective, one of the definitions I saw was when someone, it has a connotation that someone's in an uncomfortable state. And so I think the circumstances are important. And here, the defendant's telling her, I'm going to violate this court order for almost a year before he does it. And he knows it's in violation of the court order. And it's not, a minute that he's late. He's in another state. He's actually physically in possession or custody of the child.
No, I thought about that. I thought about the taking out of state part, which seems egregious to me. But on the other hand, this isn't a statute about taking out of state. It doesn't seem to care where you go, but just how long you go for.
Right, I think the taking out of state, if I remember correctly, you have to prove all the other elements, and then that's kind of a enhancement, like a a more serious version of the crime.
Can
but-
you, time is short, can you talk about, you mentioned him saying, or apparently knowing that he was violating this court order. What do you say about this, it's a copy of a certified copy piece?
The authentication issue?
Yeah.
Sure. The Duramo case, it doesn't give a lot of details about how the exhibit was entered into evidence, based on my recollection, but it's very focused in how the prosecutor chose to do it in that case. And the way the prosecutor chose to do it is by submitting what arguably may have been thought to have been an attested copy, although it was a copy of an attested document. So that case, the reasoning, the explanation, the arguments are very focused on that manner of authentication.
This
And
is a
it says-
copy of an attested copy.
No, I don't even think there's an attestation on it.
Well, what is it then?
It looks like it was a version. Based on the evidence at trial, it seems that it was a version the court sent to the parties without, any request by anyone to actually attest that it's a true copy. So,
So it's not even a copy of an attested copy, it's just a piece of paper.
double check it, but
Yeah,
my
it's got a file
recollection of
stamp, but
viewing
there's
it
no
didn't.
attestation on it.
So the Duramo case, they even say, I'm just trying to get back to my train of thought. The language at one point in the decision talks about the requirements of attestation. So it's very focused on that method. And it ignores, I think it's 40C.
It says it's required.
When you choose
First,
to
it looks
do
at
it
section
under that statute.
76. First, it looks at section 76, which in my view doesn't say it's required, at least in its text. But Duramo says, having been given this way to introduce competent evidence of a public document, you have to use it.
Well, section 76 doesn't say how documents or records of a Department of Commonwealth have to be authenticated. It says copies of such authenticated by the attestation of the officer who has charge of the same shall be competent evidence. So it's almost,
Yes, but we have to follow the SJC, which seems to have said in Duramo, not just that's one way to do it, but that's the only way.
that language, I didn't read that language in the decision.
Okay.
That decision in the Commonwealth's position or interpretation is that in these circumstances where the only way or method of authentication at this trial involved attestation of a department agent, the RMV representative, this is how you need to do it if you're going to do it that way, and you didn't do it correctly. So that's the Commonwealth's interpretation of Duramo.
I don't really understand how a Xerox of a blank sheet of paper with some typing on it could be better authenticated than a Xerox of an attested document. Do you see what I mean? I mean, the Xerox of the attested document, again, people tamper with things more now than then, but still, that's a real one that's been copied, and this is, even crediting the testimony, this is something that was mailed.
Oh, in our case? Right. So, but just remember, authentication is really an issue of relevancy. We're not talking about hearsay, whether it was admissible under hearsay rules. It's really just authentication, which is really the question of authentication is relevance. Is this what the proponent claims it to be? And it's a really low standard. And the evidence, came from the complainant, who was a party to this court order, who was involved in the process that led up to it, who has knowledge surrounding it, how it was issued, why it was issued, when it was issued, has the relevant background knowledge pertaining to the document, can identify what it is. And that's all that's needed to authenticate something. Is this relevant? The only way it's relevant is if the proponent claims, if it is what the proponent claims it to be, and she showed that. Hearsay is just a separate issue. I just want to check something. I will say the Beals case, I didn't cite it in my brief because I think I don't recall, but I do remember reading it in preparation for the brief and reading about how a parent cannot be convicted under this statute if there's in the absence of a court order stripping them of their rights to the child or to custody of the child. But when I reread it for oral argument this week, I noticed that it doesn't define protracted, but when it talks about the statutory language, it uses prolonged in place of protracted, at least in one area. So whatever that's worth, I just want to submit that to the court.
Which case was that again?
The Beals, Commonwealth versus Beals.
Beals.
And I can give you the site, I wrote it down. It's 405 Mass 550, 1989.
Thank you.
You're welcome.
Okay, your time has expired.
Thank you, Your Honors.
Thank you very much, both of you, for excellent arguments. The case is submitted. We are going to take our traditional mid-morning break, and we will return in 10 to 15 minutes. So court is in recess.
All rise, please.
Good morning, welcome back. We will move to our next case, which is Parella versus United Site Services Northeast, Inc., number 23554. And we will hear first from Attorney Elwell.
Good morning, and may it please the Court. Dean Elwell of McCarter and English for the appellant, United Site Services Northeast. Given the posture of the case, an interlocutory appeal from the grant of a preliminary injunction, I want to start with a fundamental problem. There is no irreparable harm supporting this injunction. This is an employee non-compete case. The employee, Ms. Parella, if she were to suffer any harm, it would be compensable by monetary damages. They're all measurable.
So how's that? Do you agree that if she wins, she can establish what she would have made if she could have competed, and client will have to pay all that?
That's right. That's right. These are classic non-compete damages. Let's look at what the Superior Court said, how they constitute irreparable harm. The opinions in the record at Appendix 165, Addendum 51. We're looking at the third paragraph from the bottom. Plaintiff must either forego employment in her long-time line of work or go forward as she wishes and risk legal action and potential loss of employment. These harms, the Superior Court said, are likely not remediable by monetary damages. No citation. How is that the case?
You're aware of the Declaratory Judgment Act.
I am.
The Declaratory Judgment Act, while not expanding our jurisdiction, allows people to sue when the injury is imminent. They don't have to violate this thing and then be hailed into court by you all. So when is it imminent?
That's right. This is a related problem. This is a threshold problem, actually, a jurisdictional one. Let me turn there first. When the General Assembly enacted the Declaratory Judgment Act, it didn't relieve plaintiffs of their burden to prove subject matter jurisdiction. And this court made that clear in 2019 in Statewide Towing Association versus City of Lowell. We cite that on page 19 of our opening brief. It doesn't open these courthouse doors to abstract questions or hypotheticals about what a contract might mean in the absence of an actual controversy. There must be an actual controversy. So the question is, what is an actual controversy? The SJC has defined that. What it requires under the Declaratory Judgment Act is the plaintiff to take some steps toward a breach of contract. No, not a full breach, but at least enough steps to establish that actual controversy.
Sending a letter to you that says, I want to go into the portable toilet business. That's not a step.
She said she desires to return to the industry of temporary site services.
Yes, so, yes.
Right. No, that's not enough to constitute an actual controversy. We don't know whether that would be competition. She can't enter the Superior Court.
How could it not be competition? That's what you do.
For example...
And she's described it as the only industry she's ever known. She worked for you for 19 years. So I think we can infer that the only industry she's ever known is yours.
That may be true, but when she says return to the industry, we don't know what she would do when she gets there. If she goes to another temporary site services business, granted it's that kind of business, but she mops the floors, that's not competition. If she does customer accounts, if she handles customer accounts,
You
that's
don't think we could
probably-
infer that she's going to be a saleswoman, as she's been her whole career?
Well, we don't know. The record reflects that United, for example, hires individuals with experience in other industries.
Yes, but
for
she's
their
not, she
business.
says, she's not saying I want to do sales in another industry. She's saying
You
this.
don't hire 19-year saleswomen to mop the floor, do you?
No, we don't. But the point is, she hasn't alleged what she would do at that competing business. There's no evidence in the record that what she would do is compete. Think about it in reverse. If she doesn't need to take any steps toward a breach, then every conceivable ambiguity in a contract is a justiciable question. That's not what the
But we
Declaratory
have to
Judgment Act
believe that
does.
she paid some lawyer to write a letter to you because she's curious?
She
I
can
mean, that
pay-
doesn't sound plausible.
She can pay a lawyer to give a legal opinion about what the word competition means. It's not defined in our contract, but she can't go to the Superior Court and ask it to define that word for all intents and purposes. In effect, that's what the Superior Court did here. It says, under no circumstances may United proceed against Ms. Parella for competition under Section 7A. That's too broad. It cannot be defined in the abstract in that way. It must be application of law to facts. That's what the courts do under the Declaratory Judgment Act. Lawyers are allowed to define things in the abstract, but not courts. The reason
I don't understand why that's abstract. If your agreement is completely unenforceable as written, then it can't be enforced, right?
That's correct.
So what's abstract about that?
The Superior Court struck it down on other substantive bases. Our issue was the Superior Court should not have proceeded to those merits bases. There was not sufficient allegation in the complaint, which we attacked on its face, to confer subject matter jurisdiction on the Superior Court. There was no standing, there was no actual controversy under the Declaratory Judgment Act. The reason I say that's related to irreparable harm is that, as I've just explained, she hasn't alleged any legal harm, but if she had, those legal harms would be compensable by monetary damages.
Did you say below that your client, if you lose, is willing to pay her whatever she would have made competing against you for the 3 years?
No, there would be some argument and analysis, and there has to be evidence about what those damages are. But the point is, they would be damages.
Did you tell the judge below that if it could be proved, you were going to pay those damages? So I was a little surprised to hear you say that, and I don't know if the judge below knew that that was your position. You were willing to pay her whatever she can prove she would have made for 3 years.
I understood Your Honor's question as if we were found, if this agreement were found unenforceable,
Yeah.
and she had proven damages that she suffered because of this agreement.
She proved I could have made such and such money if it weren't for this agreement.
Right.
Over the 3 years.
Right.
And you're saying then you'd have to pay her that money under those circumstances.
I understood Your Honor's question is if we were ordered, if that were the order on damages, then we would, of course.
No. You say she has a monetary remedy. And the only way she'd have a monetary remedy is if, to the extent that, assuming it's unenforceable, to the extent she could prove that absent this agreement, she would have over those 3 years made such and such money, working in the industry or starting her own business, that you would then be obligated to pay her that money.
I think the issue is it's not an equitable remedy. It is a legal remedy of some kind.
It's a legal remedy if what I just said is true. If what I said is not true, then what's the legal remedy?
If what you said is not true, the legal remedy may be simply the dissolution of the contract. If it's declared unenforceable, substantively, if the Superior Court has jurisdiction to make that finding, then she can go and compete.
Okay, but if she gets no remedy until the litigation ends, by which point the 3 years will have run anyhow, then she really doesn't, her harm really is irreparable, because there's no remedy, right? And what am I missing here?
You're saying by the time the contract, by its terms, has expired.
If you're telling me that absent a preliminary injunction, her remedy is that eventually it will be held unenforceable and then she can compete, then what's her remedy for all the time that she was not allowed to compete wrongfully?
Right, and so we're coming back full circle to the damages. If she's able to calculate and support what damages are for that period of time, then the court may so order if it has found the contract unenforceable.
And you agree your client would have to pay whatever she could have made during that time, assuming that it's found unenforceable?
And adequately supported, I don't see what other remedy there could be.
But is that, I know there's no other remedy, but is that a remedy, is my question. I've never heard of this theory that you sue or non-compete for what money you would have made if you could have competed. So if you're telling me that is a remedy, I want to hear.
I have never seen a case to that effect. If there are damages under this, it would be measured in that way.
But can you recover those damages in that way? Can she recover those damages? I understand that that's the only way she could recover if she has a remedy, but I want to know whether there is a remedy before you tell me that there is a remedy, and so therefore we should deny the preliminary injunction.
Yeah, I believe that she could collect those damages if the Superior Court so found, yes.
Can I ask
So
you
did you
about?
tell,
Oh, no,
I'm
go
sorry,
ahead.
just got one more.
no,
Did you
please.
tell the court below that?
No, that was not before the court. We attacked it on subject matter jurisdiction, saying if there were damage, if there was an injury here, they would be measurable in dollars. That's as far as it went.
Okay.
You spent a lot of time on this rather than on likelihood of success on the merits. But let's talk briefly about likelihood of success on the merits.
Sure. So I think there are two areas here that we should discuss. The first is the protectable interest analysis. This court and the SJC have long recognized that sales employees like Ms. Parella are particularly suited to harm an employer's goodwill, and that's for two reasons. First,
The
because
judge said it was de minimis,
that's right. We think that finding was erroneous.
right? And so the judge then said, I have it here somewhere, that the agreement is not necessary to protect a legitimate business interest. Is that a factual finding, not necessary?
Well, I think it was a mixed question presented to this court. There's a legal conclusion, of course, that it's not enforceable under any and all circumstances.
No, that's the consequent, that's subsequent to this logically. This question is there likelihood of success on the merits at all? Never mind whether it's the whole thing or it has to be now what the remedy is. And I'm saying the judge said not necessary. That sounds like, I could be talked out of it, of course, but that sounds like a fact. Is this necessary? No, it's not necessary. Is that a legal conclusion or a fact?
What the Superior Court was discussing there was not necessary to protect a legitimate business interest.
Yes.
We do have legitimate business interests here to protect, and those are...
The judge didn't say you didn't. The judge said that this wasn't necessary to protect it. The judge didn't say you're not a business or you folded, or obviously you have some legitimate business interests, but she said they would only minimally be affected by anything the plaintiff might do. I think that's what the judge said. I may be misreading. I mean, it's a short order and I may be misreading it, but I thought...
No, Your Honor is correct. She does use the word necessary to protect, the phrase necessary to protect a legitimate business interest. She's quoting a case. That is a factual finding of the Superior Court. The problem is it's tied intricately to her finding that there was only a vague assertion that the plaintiff possesses confidential information. And that's not true. What the defendant showed below was that it has confidential information it has given Ms. Parella.
Pricing?
Pricing and inventory,
And
which is not
inventory.
commonly known in the industry.
I thought that the judge found that it was commonly known in the industry.
There was an affidavit submitted below to that effect. What that was more like was the general concept that pricing and inventory are known, such as the price of gas at a gas station. That's generally known, but it's not known how, for example, a gas station along the highway charges so much more. Of course, we all know, public knowledge, they charge a lot more, but how they settle on that price point is not commonly known. So that United charges a particular price point is higher or lower, that's commonly known, but how they got there, that's not known. Ms. Parella, a 19-year employee, says she can match, quote unquote, her customers to the best equipment at the best price. How would she know what the best equipment at the best price is for those customers?
Well, if she's running a business, she's going to have to look at her cost basis. She's going to have to look at what profit margin there is. And then she's going to have to look at, can I sell any of them at this price, right? And if she can't sell them for less than you, that, if she sells them at the same price, she'll have to argue that her business is somehow better than yours. If she sells them lower, she may get customers who want the cheaper ones. If she has to sell them higher, then she's got to push harder on customer service or something. I mean, I don't really see what's confidential about how you determine your pricing when you know what someone else's price is.
Well, she has inside knowledge about what those customers use, what they prefer in the best equipment at the best price. Those are subjective terms. She knows through a course of dealing with them over 19 years what they need. She will carry that knowledge with her when she leaves. That's the protectable business interest. That is why it was necessary to protect.
What do you say to the plaintiff's argument that the non-compete is not enforceable against her because her job description changed so much under the Bartlett case?
Right. This material change doctrine, it doesn't apply, as we've set out in our brief, when any of the following three things are met, and all are true here. The contract provides the employee's duties may vary, that's per the SJC and Slade-Gordon. The covenant survived termination of employment per ARS Services and NACWA, or the agreement may be modified only by a subsequent writing, that's per Athena Health. This agreement does all three of those things.
I have more questions.
Please.
So your second argument is about the scope of the remedy. And the first thing I'd like to know is what what reductions of the covenant do you believe you preserve below?
What reductions?
Yes, you're saying that it's just states all unenforceable. It should have in fact been reduced, since you make no argument that it was enforceable as it was. But which reductions do you think you preserve below?
I think we preserved all of them. The contract
Well, okay,
itself,
all of them, but what, could you tell me what they are?
Sure. The temporal limitation. If this agreement were deemed unenforceable, the contract by its terms, the parties agreed it should be reduced. So the first is in time, from 36 months to a shorter amount of time. In geographic limitation, that may be appropriate as well.
Okay, now what geographic limitations do you think you preserve below?
Those in which, just as the Superior Court said, Ms. Parella actually performed services. This would all be consistent with the 2018 Massachusetts Non-Competition Agreement Act. Those bases, reducing it to consistent with those.
Where she preserved services?
Where she performed services.
Okay. If we decide that the proper temporal limitation is 16 months, why wouldn't we just affirm, since it's been 16 months now, and there couldn't be any more restrictive covenant going forward? Again, assuming there's subject matter jurisdiction.
Yes, I take Your Honor's point. This case still has a lot more time to go, but if it is reduced, by its terms, it would end in September of 2025, 36 months from September of 2022. If it were reduced in scope, then that may be the practical effect.
It hasn't been stayed pending appeal.
It has not.
Did your firm draft this agreement?
No, it did not.
All right. The last thing I want to ask about reducing the scope is, of course, you can only reduce the scope to the extent the agreement's severable. And the way this agreement, which I'm relieved to hear your firm did not draft, it says that the agreement shall be enforced as so modified after the expiration of the time within which the judgment may be appealed. So when the contract says it's only limitable at the point at which judgments happened and the time to appeal has expired, how can a judge pre-judgment reduce its scope when the contract says that?
We're not suggesting that at the preliminary stage there should have been a modification at that time. But what we are suggesting is, on a motion for a preliminary injunction, what the court has to do is look at what would be the ultimate effect of a permanent injunction, comparing those two scenarios. At that time, at the time of permanent injunction and judgment, then the scope would be reduced.
Got it. Okay, thank you.
I see no further questions. Excellent argument. Thank you very much. We will hear next from Attorney Gordon.
Thank you very much to the panel. Good morning. My name is Kenneth Gordon. I represent the appellee, Donna Parella. This is an appeal from a preliminary injunction that was granted on March 30th, 2023. As you've been discussing, I just want to comment a little bit about essentially what I just heard, because that's really the theme of this case, what's been going on. Many of the positions that Ms. Parella has been put in are just not reasonable. For example, as to irreparable harm. How is she going to prove what her damages would have been 3 years after the fact, when if what she wanted to do was go into business for herself, she could have had a business up and running, getting goodwill for itself, and how can she go ahead and reverse engineer where she would be if this didn't happen? That's why there's irreparable harm, Your Honor. Who cares how she would have gotten to her price points? The issue would be, this is what I charge, and she knows what she would charge, because this business is one in which they rent porta potties to construction sites. They know the needs of the construction sites because the construction sites call them up and place an order. That's why you see the affidavit of Anthony Mattis, that's USS's employee. He says that the job changed for Ms. Parella in April of 2022 because she had saturated, because United Site Services had saturated some of the accounts, and to help themselves, and they said Ms. Parella, they wanted to move her to a different area altogether, removing her from her supervisor and Mr. Byrne to a new supervisor, changing these conditions of her employment. Now she had to go out, get all new customers. Well, if they were secure that these accounts that were saturated, again, they knew how that business came in. The contractor called the company, placed an order. They relied on the company to deliver a porta potty. There's nothing complicated about delivering a porta potty and picking it up again. And they would do that routinely because that's how they essentially keep them clean, by doing it weekly. And managing health code, which is really what this is about. That's all she would do. That's all she would do. And that's why she has no knowledge that would be harmful to their protective interest.
She has relationships with the customers, doesn't she?
Not really. And the reason that we know that is because of the Mattis affidavit, where it says we're going to pull her off of these accounts and put her on different accounts. If she had a relationship with a customer directly that was valuable to the business, they wouldn't do that, because they would be afraid that with now a new salesperson...
Well, they might do it.
I'm sorry?
They might. They might feel like, what's up with this person? She seems like maybe she wants to start her own business and she's close with these customers. We better get her off those accounts so that we have another one of our people building relationships. We may need
That's not what they said. What they said was they took her off of those accounts to put her on different accounts, a new business, so they would trust her enough now.
But they didn't write because she doesn't have, all the customers hate her and she doesn't even know them and has no relationship with them.
There's no, again, they're not saying that either, because they said these accounts are saturated, so no one would hate her if they were still ordering from her. The issue really is they order from United Site Services if they get good service. If they start to get poor service, they wouldn't do it anymore, because there's nothing that she could do to get better or worse services. All that she does is takes the order and relays it to the company so they can deliver the
I mean, you're kind of attacking the very concept of hiring salesmen and saleswomen.
Oh, no, it's
saying they have no effect on the sales. It's all based on the underlying company.
I'm saying that in her case, because the product is not unique, she's got to be a diligent worker. She's got to show up. She's got to answer her phone. She's got to be a pleasant person.
Sure, and that's in a way, lots of times, the tipping factor in who someone picks.
Right.
It's true, it's $8 more a day here, but at least I know there'll always be a porta potty. At least I know I can call Donna, and if anything's going wrong, and that she'll, even stay late to try to do something. She's so great. I mean, that's what salespeople hope for, of course.
Okay. But isn't that what Judge Cowan would say is de minimis? Because that's a run-of-the-mill thing that people do, or salespeople do. That's not unique. That she's reliable, that's not unique.
No. I mean, I don't know. We're talking about pre-existing relationships, right? We know all the time lawyers leave firms and steal the clients, right? How do they do that? Are they charging $5 less an hour? And the answer is no, the client trusts them, and that's who they want to have do the work, and then they go with them.
But the difference is the lawyer does the work. I get hired at my firm, and then I do the work.
Sure.
Ms. Parella gets an account, and then others deliver the porta potty and pick it up again and make sure it all works. And that's a big difference, because that's why in some businesses, you would carry the goodwill because you're the one that performs a service. If I'm a, I can't off the top of my head think of one, but, this is a person that takes these, or she does a great job.
Your friend said something pretty interesting, and it was something he said below in front of Judge Cowan, which is that the agreement could be limited to just her working with the clients she had before. Why isn't that a reasonable way to limit this non-compete
Because
agreement?
there is no non-solicitation agreement. They didn't ask for one, she never signed
Well,
one.
it says not compete at all, and you could, not compete at all for 3 years anywhere, basically. That's obviously unreasonable. They don't even argue that it's reasonable. But one way to pull it back is to say, okay, well, just where you were with the people you talked to.
Well, I'll stand with my first answer, which is there is no NSA, and we know those are common. But moreover, this is an employer that has a 3-year agreement written there, a geographic area that's vast. And so the reason I think that would be unreasonable is because this employer is basically in a situation where it's sort of heads I win, tails you lose. I am going to hope that you don't go to a lawyer and that you're frightened into staying away from us for 3 years. But if you do get one, it's okay because I'll keep the accounts that you had any contact with, so I get something out of it. I don't think that that's a position that...
They could have put in a severable non-solicitation agreement, and at the end of the thing said, if any paragraph of this is no good, the other ones remain operative or whatever. But there's nothing severable from this. You'd have to literally rewrite it.
Right. They didn't. And that's my argument. It's not there. And I just don't think that a reasonable result would be they still win because they still get to keep some of their interest while trying to essentially terrorize you in an interim clause into less. So I could go on, and the issues before you are standing, and very briefly, I think that the court's questions got to my argument, which is the letter was the standing. The letter looked at the restriction, and it said, without written permission, prior written permission. So prior to her doing anything, she says, can I do it? And they don't give her that permission. That put her into the problem. Now she's in a controversy with a party in contract. She can't go ahead and work unless she wants to breach the agreement. And I don't think she should be required to breach the agreement, and neither does the Medlume case that I cite. I don't also think it's reasonable that she should be required to do the things that are not in the test, but that the company says she should do, which is involve other people. It says she didn't go in on any interviews. Well, she didn't go on any interviews because before she did that, she wanted to know if she would have to tell the potential employer that she was restricted. So she didn't get to that step. And she certainly didn't go out and get investors or clients for a new business before she knew whether she was free to do that. And that's why she has standing. With respect to the change in the material terms and conditions of employment, our next argument, that goes to why this contract is no longer enforceable.
Right, but no longer is the key here. The change happened in April 2022.
Right.
So even if there was no agreement not to compete after April 2022, wouldn't she be barred from competing until April 2025 under the old agreement?
Under the old agreement, yes, under the old agreement. If the old agreement was enforceable, that would be the case. We don't think it was. Your Honor, we don't think it was for that first reason.
I understand.
Yeah, that there was that material change. And the
Well, no,
reason,
well, I thought you meant because it's totally unreasonable and broad, and I don't understand why, if you materially changed your job such that you'd have to have a new non-compete,
Right.
why that would eliminate the non-compete you already had agreed to in your prior position with the company.
well, that's the Bartlett Tree case, the Bartlett Tree case.
Well, no, it just says that there's no non-compete from starting from that point where there's a material change. But I don't understand why the agreement that she had until April 2022 wouldn't still be enforceable. If they just fired her in April 2022, she'd be subject to the non-compete.
So I'm not sure I quite understand the question, but I think our position is that until the material change, the terms of the prior employment agreement she signed, they were still there. Whether they're enforceable or not is a matter of law. But after April of 2022, those terms were extinguished by the material change in the employment.
And I take it you have some position with respect to the, I think, kind of oddly written language of the agreement that says that even if it's terminated, it doesn't expire. People can agree to get rid of an agreement, so I'm not sure I fully understand what, do you think that means something? Or you think that when the termination is like this, I still work here, but I no longer have one,
Right.
that it replaces all of the pre-existing terms, even if the pre-existing one says, this survives termination or whatever.
Right. I think those are mere contract terms that don't survive, just like the other contract terms. Once the material change in April of 22 happened, all of those become contract terms that expired. And I think that for the purpose of this argument and for this panel, we don't have to look back to 2005, 19 years ago, to see what those terms said, because in 2017 and 2020 and 21, the parties demonstrated that each time there was a material change in employment, they knew that there had to be a revival or an affirmation of that language for it to continue forward, and that's how they acted. They didn't act that way in 22, so they knew they were proceeding.
Did the judge make a fact finding on whether she had been offered or asked to sign non-compete in the April 2022 change, and that she refused to do so?
There was no fact-finding in the order as to that.
Well, there's some fact-finding in her order, and I don't really understand how you make fact-finding without hearing anybody.
Right, right. But our position is whether she refused to sign it, as she says, or
Yeah.
whether she was never presented it. Nobody says she did sign one, and that's what was required. So whichever way you get there, there's no dispute that there was nothing signed. Nothing's been produced with a signature. And so that's what creates the condition that there is no enforceable employment agreement with respect to this employment relationship after April of 2022. She's working there without an employment agreement.
Right, but why does that eliminate the old agreement as to the stuff that happened before April 2022?
I don't think it did. It eliminated the terms of the 2005 agreement as affirmed by the next two, because that next step happened, which is that as it happened in 17 and as it happened in 2020, there was a material change that required an affirmation of any prior agreement. Had she not affirmed that prior agreement then the 2005, the 2005 agreement would have been extinguished then.
What I don't understand is on March 2022, she can't compete for 3 years until March 2025, assuming that there's anything enforceable about this agreement.
Okay.
So then, in April 2022, she's working without a contract, but why would that eliminate her duty not to compete under the old contract until March or April 2025?
It would eliminate it because it was no longer enforceable, because the contract in which that restriction appears is no longer enforceable pursuant to the Bartlett case.
But usually if I have a contract with someone and it expires and I do stuff with them after that without a contract, doesn't mean that the old contract becomes unenforceable to the stuff that happened back then.
But the significant term that we're talking about, I would argue, doesn't carry forward with it. You may now be an employee at will, and you may now be entitled to be paid, and you may have an obligation to perform the services, but not pursuant to the terms and conditions of an employment agreement that go beyond the employment at will doctrine.
All right, your time has expired, although I want to We gave the other side a little extra. If anyone has any questions, no?
Thank you.
I see no further questions. Thank you very much. Very good argument, very helpful to us, both sides. So thank you very much. The case is submitted.
Thank you, Sam.
The next case is number 23313, American Graphics Institute LLC versus Noble Desktop NYC LLC and another. Before we begin the argument, I should explain to counsel and for the record a couple of issues that have come up this morning with respect to the case. The court received a motion this morning by email, which asserts that it was also sent to appellant's counsel by email from counsel for the appellee. It is a motion to continue the argument or to appear by Zoom. Based on the non-presence of counsel for appellee, not due to any health or other excusable circumstance. We have denied that motion, and so we will proceed with argument even in the absence of counsel for appellee, who was given clear notice that the argument would be held this morning. So we will hear from Attorney Mangonis for American Graphics Institute.
Thank you, Your Honor. I intend to confine my argument to three distinct points, given the volume of the record and the number of arguments. And those 3 points are whether American Graphics was in fact penalized for an action to comply with a court order, whether or not the $50,000 award for Morikatan's time and effort derives from the essence of the arbitration agreement, and whether or not the superior court's or interpretation of the arbitration clause as permitting attorney's fee shifting in this motion to vacate was erroneous. So starting with the first argument, American Graphics, there is a doctrine of case law that permits the court to vacate an arbitration award if it is in defiance or if it offends a public policy. We have put forth an argument that in this case, there was a finding of the arbitrator that when AGI took down certain website pages on around February 8th, 2021, that it violated the transition clause of the purchase agreement, but AGI had taken those web pages down specifically to comply with a preliminary injunction that Noble had sought and received.
Was there any testimony or any other evidence from the Smiths or anybody else at AGI that the reason they took down what they took down was to comply with the injunction?
I don't believe so, primarily because this wasn't an issue for the case. This wasn't a fact that was put either in the complaint or the amended complaint, both of which were filed after this occurrence of taking down the website was. This was not by any means a primary reason by which Noble Graphics was contending that AGI breached Section 4.1. There were volumes of instances of why Noble Graphics believes AGI breached Section 4.1, many of which the arbitrator found. But that specific fact was not in the complaint or the amended complaint. It was raised effectively at the time of the hearing. It might have been mentioned in their pre-hearing brief, but it didn't even get that much attention at the evidentiary hearing itself. It was highlighted in the closing, which is why it was addressed specifically in AGI's
proposed findings and rulings. So the answer to your question, I believe, is actually no. But it was certainly addressed in the findings of rulings simply because I, as counsel, listening to the closing argument, said, wait, what? As they're belaboring this point about destroying all the value by bringing these pages down. And so I made sure to address it in the request for findings and rulings. It really wasn't given much attention in the evidentiary hearing by either side. So there, just so the court is aware as to why we believe that those pages needed to come down, is Noble Graphics had gone into the New York court, put those instances of those pages in color up on a verified complaint and said, look what they're doing. They signed a non-solicitation clause. They've got all these pages.
But you certainly could have kept them up, but stopped calling them AGI cases and called them Noble classes.
That's correct.
But you decided not to do that because you wanted to destroy the value of the business, right?
AGI did, so I believe what you're saying is they could have changed the name.
The problem was you were
AGI
listing the
to
Noble
Noble.
cases, Noble
That's
classes,
an
you were calling them
interesting-
AGI cases, and you were just giving the Noble address, but you were calling them AGI cases. But you could have left them up and said, here are some Noble cases, and, you know, Noble we're transitioning to. You should start, if you're New York people, you should start using Noble. But instead, you decided to just take them out altogether.
Well, if you actually look at the affidavit that Morikatan filed for contempt after we took these down, Morikatan said it would have been an instance of contempt simply by the fact that we merely list a presence, a New York office, even though we're listing Noble's address.
Someone wrote that Catan emailed AGI on February 9th, 2021, and stated the courses run by Noble should remain listed on the AGI website, and only the AGI-run courses should be removed.
So,
And then you wrote that.
I didn't write that. That was
Right there, I'm reading from your brief.
So I read it, absolutely, that is absolutely the case. And so the response to that was, you guys came, we now have a preliminary injunction that's preventing AGI from soliciting to New York. Just to cut to the chase, your point is correct. If they had changed the name, if they had done something differently and changed the name to Noble Desktop, then hypothetically, that may not have been violative of the preliminary injunction, although it would have still been listed on the AGI website. That wasn't something the AGI contemplated or was willing to do at that time. Absent that, they had to take down those web pages.
Willing to do, you're saying it was required by the injunction, and I feel Justice Ditkoff has just suggested a way that you could have addressed the injunction without completely removing Noble's courses from your web page.
By actually saying this is a Noble Desktop course.
I mean, I also have to say, excuse me, I think our cases say, certainly this is what opposing counsel argued in the brief, that the award has to violate public policy or we don't disturb it. Even more now that there's this other possible reading of the injunction, I feel like what you're challenging here seems like what you say is a legal error by the arbitrator. And we can't do anything about that, even if you were right.
I understand, and I would like to, given I'm at 8 minutes and 24 seconds, I would like to move on to other aspects of the argument. The next one being this $50,000 in time and effort, which the arbitrator called admittedly arbitrary, which was not.
Were you saying that an arbitrator can't be arbitrary?
No, I'm not saying that.
Does arbitrary mean discretionary, or does it mean capricious?
I wouldn't seek to vacate on the fact that it's arbitrary. I think the argument we have ultimately is stronger. That first of all, it wasn't sought, but let's say that's not even a particularly strong argument. I think what is a strong argument is that it really wasn't that arbitrary. There's this testimony. There was a wholly separate contract that provided the compensation for Morikatan to help integrate this business. And that was a contract that was not subject to arbitration because that arbitrator ruled that it was not subject to arbitration. And so there's this colloquy, which we put forth in our reply, where the arbitrator says, well, isn't Morikatan's time and effort something that he deserves compensation for? And Christopher Smith said, yes, that's provided for in the contractor agreement, which is this other are not subject to arbitration. And she says, well, has he been paid? And he said, Christopher Smith said, no, because we believe he breached that agreement. So she said, so he hasn't been paid. And then we have this award of $50,000, which is the exact same amount that.
But I thought your argument was not that this was outside the scope of arbitration, but that it was based on no evidence.
Well, it's that it doesn't derive its essence from the arbitration clause, is the standard to vacate. So if the arbitration clause relates to the purchase agreement, and that was what gave rise to the arbitration, our argument is that the $50,000 can't derive its essence from the purchase agreement and the arbitration clause because it derives its essence from the contractor agreement, which is not subject to arbitration.
Do you think an arbitrator can set an amount if there's evidence in the record supporting some compensable work?
We have a.
Do you think that the arbitrator can say, I'm not going to sit down and parse every hour these people worked. It's clearly more than X dollars, so I'm going to just award X dollars to save everyone the time of figuring out if it's really 68 or even 150 or whatever. It's clearly more than 50. 50 is what I'm doing. I'm an arbitrator.
I think that point is pretty clearly covered by the Seneoff case. There is a standard which I think is very strictly applied, whereas if there's no facts in the record, then it can't have derived its essence. I'm not pushing that line here with this court. I think we have the better argument that the $50,000 is the number stuck in a different agreement, which was not subject to arbitration, and that testimony and colloquy was on the record with the arbitrator. It doesn't look admittedly arbitrary at all. It looks like she awarded damages for breach of a contract that wasn't before her, and which is actually Noble seeking to recover for that in a separate action. So that would be.
You're saying, wait a minute, that the arbitrator got that $50,000 from some other contract? I read her to be saying it's admittedly arbitrary but conservative, and it's based on Mr. Catan's extensive testimony about the steps he took between May and December 2020.
Well, that is the finding, but there was also, the arbitrator inquired about how much is, about whether or not Mr. Catan could be compensated for his time, and it was brought up, the witness brought up that, yes, that's part of the contractor agreement. And the contractor agreement
Saying she was required to credit Smith's testimony instead of Catan's?
Not at all. I'm not at all saying that. I'm saying that the time and effort component is specifically part of a different contract. Therefore, it can't have derived its essence from the purchase agreement. They were contemporaneously signed contracts. There is a standard of the law that says if the finding doesn't, or if the result doesn't derive its essence.
You recognize that if you win on this ground, you're judicially stopped from arguing in an action on the contract that this isn't covered for $50,000. You're saying it's in the contractor contract, which maybe it's been paid, but you guys are fighting pretty hard, so I'm guessing not. And you are, if we rule based on what you're saying, you cannot contest later that this May to December work is covered by the contractor contract. Of course, because you're telling us the reason it was wrong is it's covered by a different contract.
Well, no, that's actually not my argument is that the finding
It either comes from this contract or from the other contract. It doesn't come from nowhere.
Oh, for certain we would, and we have always contended, and we would be judicially stopped from contesting, that time and effort wasn't part of the contract agreement. I think what we would say is certainly he's entitled to the $50,000 as part of the time and effort, but he breached that contractor agreement for other reasons. So saying we failed on those
our defenses for the breach. But you're absolutely right that we would never go in and argue, nor could we, that the $50,000 wasn't encompassed or contemplated in that separate contractor agreement, or for the time and effort to integrate. Because that's right what it says as part of the...
For this May to December work.
For what?
May 2020 to December 2020 work. You say that's covered by the contractor agreement.
Yeah, the work to integrate the business is absolutely covered by the contract agreement. They did this purchase agreement, and then they said, Noble, you're going to be a contractor for us too, for AGI, and part of your work for this $50,000 is you're going to integrate these businesses.
Why shouldn't we award Noble appellate attorney's fees?
Because, well, I think on the motion to vacate, if you look specifically, I'm going to stick with the contractual grounds here. First of all, this is a different standard of review. This is a de novo review of a contract interpretation of the Superior Court. And so the contract is the arbitration.
I'm sorry. Oh, I see. The question of what that clause means is a legal question about the contract, not,
Sure.
Yeah, okay, I agree with that.
Right. So this is, the courts can look, the appeals court should look at this and construe it itself, Section 6.3 of the purchase agreement. Does this contract authorize attorney's fee shifting for a motion to vacate? Well, what it says is if you refuse to comply with an order of the arbitrator, that you should be, or that the other side is entitled to attorney's fees.
Unsuccessfully try not to comply.
Okay.
What would make such an attempt unsuccessful?
If you lose.
If you lose in a court case. You owe me $1,000. You say, no, I don't. I refuse to pay. I can't make you pay. I'm not allowed to bring a gun over and point it at you and say, pay me. I go into a court, and the court says, no, you have to pay. Isn't that necessarily what unsuccessfully refusing to comply means?
I wouldn't say that we've refused. I would look at that word refuse and how it's, I don't think filing a motion to vacate.
How do you unsuccessfully refuse to do something?
You try and fail.
Judge Ditkoff says to me, come to lunch. Yeah. And I say, I'm not going to lunch with you. All right, if I'm unsuccessful, something must have made me go to lunch with him, right? I tried not to. Although I would always say yes if you invited me to lunch, Judge Ditkoff.
We'll see.
If you look at, I think it has to, in order for there to be attorney's fee shifting, it should be clear and unambiguous if the court's going to find it. Otherwise, the default is the American rule. When you look at this arbitration clause, that attorney's fee shifting provision is in Section 6.3b, which says if there's an order of the arbitrator, now there were 13, 14 different orders of the arbitrator that were challenged, and they sought attorney's fees and they were denied. The award is both categorically distinct, both in the arbitration clause and in the rules of AAA. So why would there be this attorney's fee shifting clause in Section 6.3b, but then you have Section 6.3c, which follows, which specifically contemplates a motion to vacate, but doesn't have any sort of attorney shifting clause. So
why would the word unsuccessfully be in 6.3b if the presumption was we're going to follow the American rule?
Well, because I think that the word Section 6.3b applies to all of these orders that came throughout the process. As I said, there were 10 or 12 pre-hearing orders. They sought motions for receiver, which were denied. They sought, there was the motion for the special master. These are all orders of the arbitrator, and I read Section 6.3b, and I think it's certainly not clear and unambiguous, as saying this is for unsuccessful refusal to comply with one of those orders. And then you have Section 6.3, which says here's an award. It's different from what Section 6.3b was describing as an order. The award is different, and what is effectively a challenge to the award, unless it's completely unmeritorious.
What do you do with the word "so ordered" at the end of the award?
Well, I think there's that one fact so ordered, but it is effectively an award. That's how it's categorized. If you look at, first of all of the other orders are captioned orders, and the AAA rules have categorically distinct rules for an award itself. There's wholly separate rules that deal with an award. And I think if you look at the arbitration clause again, like I said itself, why would, the section 6.3C, which follows it, appears to draw a dichotomy between the award and these other orders as well.
Okay, I think we understand that argument. Your time has expired, and seeing no other questions, thank you very much for an excellent argument. The case is submitted. This, of course, brings us to the end of today's session. I'd like to thank the court staff, and in particular the court officer, for their excellent assistance today, and we stand in recess.